All right. I'm actually going to record it this time. Praise the Lord. Okay. It would help if this was on. All right. So as I just said, we're going into civil rights and civil liberties. This is our next unit. We'll start today on civil liberties. That's the actual topic for today. And you'll learn civil liberties and civil rights are not really synonyms. You cannot use them interchangeably. There's a difference between a civil liberty and a civil right. Okay. Civil liberties basically protect you from government infringement or government interference, whereas civil rights protect you from discrimination, essentially. Okay. So civil liberties prevent government from overreach. Civil rights prevent your unequal treatment under the law, basically. But we'll get to civil rights in a whole separate PowerPoint. So there's a difference when we talk about civil rights and civil liberties, because it will apply to both, about substantive and procedural, right? So when we talk about civil liberties, substantive civil liberties are just things that the government can't do, right? Or I guess theoretically can or can't do. So for instance, government cannot limit your free exercise of religion. Well, no, actually they can. The government cannot, because this is a definitive declaration, the government cannot dictate to you what the official religion of the country is. Okay? We'll actually learn that your liberties are not absolute here in a minute. Procedural basically means that your liberties are protected from governmental behaviors. And so there's a set of rules. Due process is a term that you will hear repetitively throughout this course moving forward. And due process is simply the procedures that must take place in order for the government to engage in some sort of behavior. Okay. Our civil liberties are protections that we have. And specifically, civil liberties really apply to the minority. In fact, when you look at civil rights and civil liberties exist as minority protections because we claim to be a democracy, right? Yes? No? We do. We claim to be a democracy. In our self-identification as a democracy, basically what a democracy is that the majority rules, right? When the majority rules, majority opinion is actually protected by democracy. Therefore, minority opinion and minority right is what is ultimately problematic because the majority can take it from them, right? So really, when you look at civil rights and civil liberties, it's the minority that gets the protections that they so greatly need in order to sort of prevent tyranny of the masses. Just so we know, brief little history lesson. Civil rights and civil liberties come from the Bill of Rights. It's a compromise in our constitutional system. Hamilton and Madison and other Federalists did not want a Bill of Rights. They actually thought that the Bill of Rights was wildly problematic in the United States. They thought that it was detrimental to the welfare of the nation and to the welfare of the people, because they believed that if we declare the rights that you have, then inevitably we would not come up with a comprehensive, exhaustive list. We would leave something off. We would omit something by mistake, not intentionally, but there would be rights that existed that we would not mention. And we absolutely have that problem. Okay. These are some of the liberties that are not necessarily in the Bill of Rights, but they are liberties that we have that are found elsewhere in the Constitution. Habeas corpus simply means you can't be detained indefinitely. You have to be brought before a judge and be given your day in court, right? But that's the basic concept there. And the anti-federalists, those people that were opposed to the ratification of the Constitution, they absolutely demanded a Bill of Rights because they were very fearful of an overly powerful national government. And so they demanded a Bill of Rights. And so there were a number of provisions that were written. Ultimately, 12 come out of Congress and go to the states for ratification. Of those 12, 10 are ratified, and those are the what we call today the Bill of Rights. Interestingly enough, the 27th Amendment is actually a Bill of Rights amendment as well, though. Okay, our very last amendment was the 11th of these 12 that gets adopted. Okay, I'm not going to go through the Bill of Rights. Hopefully you have a basic understanding of what those are. And if you don't, there's a graphic there that you can look at that will help you. Now, you do need to understand that there is a concept called nationalizing the Bill of Rights. This is done through something called selective incorporation. But when the Bill of Rights was written, the Bill of Rights, because the Constitution pertains to the national government, the Bill of Rights pertained to the national government. And so if you go back to 1791, for instance, and you were to look at a state like Maryland, anybody know the history of Maryland? Maryland was established as a Catholic colony. Could Maryland declare Catholicism to be their official state religion in 1793? They could have. They could have. The Bill of Rights did not apply to the states. Okay? The Bill of Rights does not begin to apply to the states until we get to the 14th Amendment. Okay? And the 14th Amendment is one of our Civil War amendments that ultimately says that the Bill of Rights is applicable to state law as well, that states cannot create laws that are in violation of the Bill of Rights. And then over the course of time, a number of different Supreme Court cases have actually been what incorporates these different provisions. And so basically what the Supreme Court has determined, or what the Supreme Court says, dating back to 1925, is if the state takes this right from you, okay, if the state takes a right from you, and it is a fundamental liberty, right? Meaning without this right, you are not actually free, then the state can't take it from you either. Okay? The state cannot take it from you either, right? So if the state of Texas told you you were not allowed to practice your religion, are you a free person? No, you're really not, right? If the state of Texas tells you that you cannot say certain things, you're no longer a free human being. These are essential, absolutely fundamental liberties that absolutely exist and must be protected at a state level as well. Okay? There are some aspects of the Bill of Rights that are not incorporated. There's actually the Third Amendment, for instance, will never be incorporated because states don't have their own armies. So a state couldn't force you to quarter troops. There are also some that have not currently been incorporated, but solely because there's been no Supreme Court case regarding them. And usually the reason that there's not been a Supreme Court case regarding them is because the states already do it, right? Like your right to a trial by jury, okay? That's actually not been incorporated, but the states afford you that right as well. And eventually we see all sorts of things. And I need you to understand the whole concept here of selective incorporation, right? First of all, selective means that like we're selecting individual aspects of the Bill of Rights. Incorporation means that we're making the states abide by those provisions that show up in the Bill of Rights. But because it's selective, it takes a long time to do it. In fact, we actually incorporated one aspect of the Bill of Rights in your lifetime, right? Just 10 years ago, we incorporated the Second Amendment, right? So up until 10 years ago, theoretically, a state could have denied you your right to own a firearm, and they could have denied you your Second Amendment right. But then ultimately in McDonald versus Chicago in 2010, that case is incorporated. So you need to understand that this has been occurring, that this has been happening over nearly a century now at this point. And the First Amendment, freedom of religion, is probably one. I mean, freedom of speech and freedom of religion are equally important. But you also need to understand that you really can't have freedom of religion without freedom of speech. There's actually a lot of aspects of our Bill of Rights that are intertwined in that regard. But with freedom of religion, because it's of the First Amendment freedoms, the First Amendment liberties, it is the sort of dual-coded one. There's two aspects to freedom of religion. There's the Establishment Clause, which prevents the state from imposing a particular religion. And then there's the Free Exercise Clause that says you can practice your religion however you want. And when you look at the Establishment Clause, government has tried and has needed to, over the course of time, define what establishment means, right? So for instance, you all understand that this is government, yes? Like this building, not like this class. Like this building is government. Do we understand that concept? Right? This is local government, okay? So the Establishment Clause says that we can't have an official religion. And it's actually a little bit more than that. Not just the creation of an official religion, but basically the government can't do anything that promotes one religion over others. And then by the same token, right, like promoting one religion over another or hindering one religion against all others is sort of the same concept there. We get that? Okay. So this is a government building, right? This is a government classroom. Can I put the 10 Commandments on the wall in here? Yeah. You sure? Yeah. Why? It's your classroom. No. This is the government's classroom. This is the government's classroom. Not my classroom. This is my house. I don't own this. This is not part. This is public. This is public governmental land. Can I put the 10 Commandments on the wall in this room? No. Yes, I can. Okay. Can Mr. Sigmund? Yeah. No. Oh, wow. What's the difference? This is a government class and that's English? I'm a history teacher, right? If I solely teach it as history, right? Okay. And so just so you understand, because world history is not a requirement for y'all anymore, but there are basically Hammurabi's Code, the 10 Commandments or Judeo law, and then there's one other, and I forget the third one, but they're like I think it's Justinian Code, I think is what the third one is called. They're the first three examples of written law, right, in history. Okay, so in a history class, like if I had that on the wall, that's not promoting a religion, it's talking about history. And that's why this concept is so complex, because I can get away with it, but Sigmund couldn't. Right? Because Sigmund's not teaching you history. Right? Sigmund's not teaching you the history of law, which is what I am teaching you in this class. I mean, I'm not, but there are aspects of it that do show up, right? But if I taught world history, for instance, yeah, absolutely. That could absolutely be on the wall of a classroom in a world history class. Okay? What about like Trump's travel ban, right? Like Muslims can't enter the country. Is that in violation of the Establishment Clause? Does that hinder one religion over all others? Yes. Kind of. The answer would be yes if it was an actual Muslim ban, but it wasn't a Muslim ban. right? And this again is why it's so complex. Like Trump didn't come out and be like, yeah, Muslims aren't welcome in the country, right? In fact, he basically said like, you can't travel to America, you can't come here right now if you're from one of, I think it was 6 countries, right? Now, 5 of those countries are predominantly Muslim countries, but the 6th one was North Korea, right? Like, okay, and there were also a vast number of predominantly Muslim countries that weren't included in that travel ban, which is one of the reasons why it's sort of deemed to be permissible. Okay, now with the Establishment Clause, you all know that have you heard the term separation of church and state? Is that in the Constitution?
Yeah.
It's not. It's actually not. Right? The specific term is not. But over the course of time, we've kind of defined this as a vague wall of separation. Again, you have sort of religion, and then you have government, and they are supposed to be divided. I can teach you about the 10 Commandments in the sense of its impact or its influence upon written law, but I can't teach you the 10 Commandments about how you're going to go to hell if you covet thy neighbor's possessions, right? Like, that's now proselytizing. That's now like teaching you religion. It has, you understand? You don't know what coveting means? Wanting, right? Like basically, like the religious aspect is, if you're jealous of what your neighbor has, like that's sin, and you're gonna go to hell. Like, right? So if we talk about it in that regard, now I'm sort of teaching you religion within a high school setting. But if we just talk about, like, here is an example of somebody that actually had written law, and you should understand conceptually, and it's not really a part of this class, but you should understand conceptually that there's a difference between something called written law and something called common law, right? Because common law is simply how things are implemented over the course of time. Written law is like definitive declarative statements about what you can and cannot do, right? Just to give you a real quick sort of example of the differences between common law and written law, right? Like some of you may accidentally one day get married. Yep, accidentally. You can accidentally get married, believe it or not. In a common law sense, no, not like I got drunk in Vegas. No. Like that's probably an accident too. But no, like an accidental marriage would be a common law marriage, right? So if you and your boyfriend or girlfriend, or I guess theoretically, since gay marriage is now legal throughout the United States, you and just your roommate live together for too long. Legally, y'all married. All right. Now, it depends on the state because common law is different by state. Okay. No.
But we live together.
Will you all live together for 7 straight years?
It depends.
Okay. If you cohabitate for 7 consecutive years in a state like Virginia, 7 years is a long time. Trust me. You don't even have the same college roommates for 7 years, right? 7 years is a long time. You cohabitate with somebody 7 years in the state of Virginia, you have a common law marriage that then needs to be dissolved by an actual divorce. Okay? Just so you understand, in the state of Texas, it takes 1 day.
What?
You live with your boyfriend or girlfriend for 1 day, and you can technically be married. Now, in the state of Texas, it does require one additional thing, and that is that you have to claim to be married. Nope. You don't even necessarily need a ring. If you and your boyfriend or girlfriend live together, and then you just like jokingly go out and tell them, yeah, we got married. Whoops, yeah, you did. You didn't realize it, but you just did. Right? You don't live together in high school. One, there would be some serious legal ramifications about cohabitation for minors. 2, I mean, the reality is I jest, but if you said it jokingly, like that would not be the case. But if you purchased a house together, or if you filed taxes together, right? Like those are behaviors of a married couple. Okay, like you're married at that point, whether you want to or not. When I actually bought my house, the realtor or the woman that sold me my house told me that there was a couple that I don't know what the dude was doing, right? They had like 3 children together. They had never gotten married. And when they went to go buy a house, he didn't want her name on the deed, right? He wanted the house to just be his. I don't know if he was like thinking about breaking up with her. I didn't get it all in details, right? But then when they ran like the credit history in the background, they found out that he was filing taxes with her jointly, which means he married her legally. And so he could not buy the house on his own because she had spousal rights, which is fascinating. Okay, there is something called the Lemon test. The Lemon test comes from a Supreme Court case called Lemon v. Kurtzman, okay, that basically says there's 3 provisions to determine whether or not we are in violation of the Establishment Clause. Number 1, is the government's behavior secular? You know what secular means? Non-religious, right? So if the United States government is going to give some money to a parochial school, you know what a parochial school is? It's a religious, no, that's a fancy word for a religious school, right? Can the government give money to a religious high school like straight Jesuit? They're private. Can they get federal funds? Can they get government money? It's a complex issue. And so what the Lemon test does is tries to determine whether or not we can answer yes to that question. So number 1, if the government is giving money to straight Jesuit, is there a secular purpose for it? What if straight Jesuit is using that money to buy math textbooks? Is that secular?
No.
Yes, it is. That's not religious. Math is not religious. Yeah, math is not religious. So that's a secular purpose. Number 2, does it either advance or inhibit a specific religion? No, math does not do that. Number 3, is there excessive entanglement between government and the religious institution into each other's affairs? This is problematic with the Lemon test because the concept of excessive is poorly defined, right? Excessive is a subjective word, right? So for instance, Diego, you got an iPhone there? Mm-hmm. How much time do you spend on that phone every day?
Maybe 30 minutes.
Okay, so if I was to go pull up, because I can go look at your screen time log in your iPhone, you really gonna tell me you spend 30 minutes a day on that phone?
I want to know exactly how much time.
But so here's the thing, right?
Screen time so far, I've been on it for 2 hours and 6 minutes.
It is 10:40 in the morning.
Actually, 2 hours and 21 minutes.
It is 10:40 in the morning. Okay, now, I would argue that that's excessive. Does Diego find that to be excessive? No, because that's his regular cell phone usage. Excessive is a poorly defined concept. Okay, now, the other half of the First Amendment's freedom of religion is the free exercise clause. You get to practice your religion however you wish, with a couple of exceptions.
This is daily average 5 hours.
Oh, actually not as bad.
That's not nearly as bad as some kids that I've done this with. I've had over 10. I've seen kids that have had over 10 hours daily usage on their phones. Okay, now, the free exercise clause, y'all. Free exercise clause allows you to practice your religion as you see fit. There are some limitations, and this is one of the first things that we need to understand about your civil liberties. Your civil liberties are not absolute, right? They are not absolute. In order for you to have free exercise of religion, number 1, you actually have to be in a real religion. And the government actually makes that declaration, right? Believe me, I know, tried to start the Church of Baker, and the government was like, nope, can't do it. No, I did not really. No, but you couldn't just all of a sudden decide like, hey, we're going to start the Church of Baker. and with the Church of Baker, we have to, we have religious holidays every Tuesday, so I can't come to school because it's a religious holiday. And you can't count that against me because, you know, free exercise of my religion, right? And no, okay? It has to be a real religion. Now, that being said, Pastafarianism,
What the what?
Really? Pasta?
no, they apparently work, there's a name. It's the flying spaghetti monster.
Oh, I heard about that. They wear like spaghetti.
They wear spaghetti strainers on their head and they worship the flying spaghetti monster, and it's apparently a real religion, and some countries have actually declared it to be a real protected religion. I do not believe so. Yeah, seriously. Okay, so the second thing that you need to understand about the free exercise of religion, your free exercise of religion cannot violate somebody else's liberties or rights. Okay, so y'all learned about Aztecs in school, yes? Right? You could not convert to the Aztec religion. You could not convert to the Aztec religion and then try and engage in human sacrifice. That would not be a protected freedom of religion. Yes, the Aztecs sacrificed people to their gods. That's, believe it or not, guys, that's a fairly common, like sacrificing things to God or gods, plural, fairly common historically. But no, you cannot do that. And now, where it gets really, really complex is something like West Virginia v. Barnett, right? Or Wisconsin v. Yoder. And there's another case about like the license plates up in Vermont, I believe. Okay. So we'll go with Wisconsin v. Yoder because it's actually a little bit easier to understand than West Virginia v. Barnett. In Wisconsin v. Yoder, if you are Amish, you do not have to attend 8th grade. Or, excuse me, you don't have to attend school after 8th grade. You don't have to go to high school if you're Amish. Okay? Now, y'all understand that you are required by law to be here, yes?
Yeah.
Like, if you drop out of high school, your parents can actually go to jail. You're aware of this fact?
Yeah.
Okay? Truancy, school truancy is a crime. In Wisconsin v. Yoder, it was determined that the Amish do not have to send their kids to school after 8th grade because the free exercise of their religion dictates that they not like being exposed to all manner of different things. If you know anything about the Amish, like they don't use cars or cell phones or the internet or like electricity.
I couldn't be honest.
I'm aware most people couldn't. And now, here's where this gets interesting, right? Because you understand that that's free exercise of religion for the Amish, yes? Does that violate the Establishment Clause? Does Wisconsin v. Yoder violate the Establishment Clause?
No.
Are we promoting the Amish religion above all others? We're not. Only Amish kids don't have to go to school. Everybody else has to go to school.
Oh,
We're making an exception for the Amish. So is that in violation of the Establishment Clause? It kind of is, right? Which is where this is why civil rights and civil liberties become so complex, right? In Barnett v. WV or West Virginia v. Barnett, right? That says that Jehovah's Witnesses do not have to say the Pledge of Allegiance before school every morning. You know you're required by law to say that, yes?
Yeah.
Required by law. Jehovah's Witnesses do not have to.
someone got told for that.
A Jehovah's Witness. Because Jehovah's Witnesses have sort of very strict interpretations of certain aspects of the Bible. One of them being the like no gods before me, right? Like false idols concept. They think that pledging allegiance to a flag or to a nation is basically worshiping a false idol. That's their interpretation of that stipulation. And so religiously they can't do it. And the government has said, yeah, you don't have to do it, but everybody else has to. Which again, conceptually then creates some problems between free exercise and establishment, right? School prayer is one of those things that's constantly or repetitively come up as a result of this, because school prayer is and is not permissible at the same time, right? Like, are you allowed to pray in school? Yeah, absolutely, right? Like, that's your free exercise of religion, right? Could I begin class every day with a prayer?
Maybe for you, but.
Could I silently say my own prayer? Yes, because that's my free exercise of religion. Could I lead all of you in a prayer? Like, could I be like, we're not going to say the Lord's Prayer, our Father? Like, no. Right? Or be like, today we're going to say the Hail Mary, right? Like, Hail Mary. No. And the real reason is because I am a government official, right? That's sort of why, because it would be deemed to be state sponsored at that point. Why it would not be permissible. So here's the thing. In the event that it is student-led, it is 100% permissible.
So like for football, you don't run down.
Correct. So and here's the thing. One, again, if it's student-led, it's almost always deemed to be permissible. However, there are still some excessive entanglement aspects to it. Y'all know where Santa Fe ISD is? So it's in the Houston area. Like, they actually had a Supreme Court case about this very issue because their cheerleaders were painting like religious, I think there's Bible verses on like the little banner that the football team ran through before a game. And Santa Fe used to have prayers before their games. And then the question was, well, is the state sponsoring it? But even if, like, let's see, Diego leads the football team in a prayer before a game, right? Like, if Cavallo picked him to do it, is it then state sponsored? Right? If the cheerleaders are using government money, right, because the paper was bought by the government, the paint was bought by the government, and they're putting a religious message on a sign at a government event, which is a football game, is that state sponsored? It's a really complex issue. And I will tell you this, for the most part, this is something that the court does not really want to deal with anymore. And there's so many loopholes and ways around it. Like, y'all have been in school here, obviously, for a few years, right? Like, you remember Dr. Black. Do you remember what the announcements were when Dr. Black used to do them when he was principal here? Like, after the announcement, after the pledges, right? It was students may reflect, pray, or meditate, or engage in any other silent activities.
How's that choose?
Yeah.
Okay?
Now we got it. If you have nothing nice to say, don't.
It's not like Dr. Black didn't lead you in a prayer. It's not a violation of the Establishment Clause, right? But it affords you opportunities, and so it's a really, really complex issue. For the most part, like, I'm gonna be 100% honest with you, I've been, as a coach, I've been in athletic programs in public high schools that are probably in violation of this. But if nobody complains, a lot of the times people just look the other way. Okay. You also need to understand with the free exercise, there's a difference between beliefs and actions. You can believe whatever you want. That doesn't necessarily mean you can act however you want. Okay. And a really good example of this is actually Reynolds v. United States, which is a Supreme Court case from 1879. It's one of my favorite Supreme Court cases because it's a unanimous decision that I am 100% convinced that the entire court got wrong. Okay. So, historically, there are a number of religions that believe in polygamy. Polygamy means having multiple wives. Okay? Mormonism, although it's not mainstream Mormonism today, but when you go back and you look at the history of Mormonism, and there is a small subset of the Mormon faith that still believes in polygamy. Okay? Reynolds had multiple wives. That is a violation of the law. And the Supreme Court said no. Your free exercise of religion does not allow you to practice polygamy. Which, like I said, personally, I think that's wrong. Freedom of the press. Freedom of the press is a First Amendment freedom because it is utterly essential to the well-being of a democracy. Okay? Press has to be free, although theoretically it should be fair as well. We lost time, obviously, because of the fire drill. So I'm going to stop this. And during my conference today, 7th period, I will finish recording, and then we'll just merge the two videos. But you do have a quiz tonight, right? Okay, wonderful.